Final case on the morning docket, State of Kansas versus Randall Murray, 110213.
Please the court. Gerald E. Wells of Lawrence for the appellant. And Justice, I would like to reserve 3 minutes for rebuttal, please.
3 minutes or
As everyone on the court must recognize, this is a very unique case, simply because it is 31 years, and longer than that at this point, that a hearing was ordered by the court and never realized. Now, I want to speak of two issues in particular that surround those 31 years and their effect on due process. Firstly, I do want to take up the court's memorandum and order that essentially said that the court accepted the medical evidence in lieu of and a reconstructed competency evaluation by Dr. Reese. And I've tried to illustrate in my brief that there were some glitches and some inconsistencies, and overall the competency evaluation isn't what it should be, but there it is. Court accepted that. Now, there is some allusion to in the memorandum order by Judge Lamson that it's unclear as to whether there was a hearing. I think it's particularly important to note that all of the evidence taken together, particularly Judge Grosco's testimony, that there was not a hearing. And as you'll recall, Judge Grosco, on questioning by the state tried to get him off of his earlier testimony that there had not been a hearing. And he said, I'm not going to get off of that, and here's why. I would have made some notes on the file if a hearing had taken place and certain things would have happened as a result of that. But clearly, they didn't happen.
Mr.
Again,
Wells,
yes,
if I
Justice.
can interrupt you. So, assuming for purposes of argument that there was no hearing earlier,
Yes.
Your argument in the entire case is that there was no hearing, that there was a procedural due process flaw.
Yes.
Not that the court necessarily lacked jurisdiction to prosecute or continue the prosecution.
Well,
Because that would arise only if he was in fact incompetent, right?
I don't
I'm trying
agree
to
with that.
distinguish between procedure and jurisdiction.
I don't agree with that, and here's why. The statute's very clear, and the case law is very clear. If there's no hearing, and I would refer you to State versus Davis, which the court commented on these particular issues, it would be our position that if there is no hearing, that prima facie, whatever came out of those proceedings after that was a nullity and a violation of due process, and that's what Davis said.
And it's a nullity because of the lack of jurisdiction. That's your
Yes, yes.
So the failure to follow the procedure is not only procedural error, but a jurisdictional flaw.
Yes, but there's more that goes into it. I don't want to put the lack of a hearing and the fact that they tried to resurrect Dr. Reese's evaluation in a pocket, because I don't think it belongs in a pocket over here. I think it's part of the whole scenario that we have to look at.
But the reason I'm asking these questions is that I don't think our previous cases have been very clear on this point about whether there's a distinction, and that's probably putting it mildly. They're not very clear about whether there is a distinction and whether the remedy differs. And that's what I'm trying to get to. It seems to me that if you have a procedural due process flaw, then you may be able to correct it later with a retrospective hearing,
Yes.
as opposed to whether you can correct jurisdiction after the fact.
Well, in fact, Justice, I think it's almost imperative that we have some clarification as to the Davis case as applied to the facts of this case. And what keeps jumping out at me and should jump out to the court, 31 years went by. And but let me finish, if I might, my thought that there was no hearing. Judge Lamson seems to indicate in his opinion, and I think I used the term soft pedal in my brief, but he seems to indicate that everybody acted like there had been a hearing. But that's not what the statute says. It says either have a hearing or you don't. If you don't have a hearing, I'll use the word prima facie, is a violation of due process and the statute. And I suppose that has some influence, the fact that everybody acted like there had been a hearing. But that's not, again, what the statute says. It doesn't say if you don't have a hearing, or if somebody acts like there was a hearing, then it meets the standard. Now, what I really want to focus on, if I may, is the implication of the time factor. The time factor, the elapse of time, is one of those four criteria that this court took up in Davis. And one of those criteria, besides having contemporaneous medical evidence that might go to competency, time factor isn't really dealt with in terms of how much time is too much time. Now, if you work backwards from that theory, if it's 40 years since you've had what was supposed to be a hearing, that's a problem. Is 31 years a problem? 50 is probably a problem because most people are either in the home or they're dead or ill or whatever. But I think the fact that there has been 31 years elapsed raises a question of whether you can ever satisfy due process because of that elapse of time. And let me illustrate, if I may. Recall that this was 1983. Ronald Reagan was president. Tina Turner and What's Love Got to Do with It's top of the charts. And so we have to ask the question, since that time, 3 decades, what does due process have to do with it and the 31 years that have elapsed? Again, let me illustrate, if I may. Anybody who's ever been involved in litigation as an attorney or a judge knows that the way that you mitigate expert testimony is by expert testimony. And we've had expert testimony here from Dr. Reese, although I've complained about the quality of that report. Now, how in the world would any credentialed expert on psychology or psychiatry then be able to go back and give any kind of reasonable explanation or mitigate that testimony by his own evaluation?
Wouldn't that, if we accepted that argument, wouldn't that essentially render all retrospective competency hearings not feasible or not possible? In other words, why does the 31 years matter? It seems to me that argument would apply if it was 2 or 3 years later. I mean, don't you still have the same difficulty?
Well, you had 3 years in Davis, and I would suggest that if you have 1 year or 2 years, it's entirely possible to reconstruct and mitigate that testimony. But 31 years, memories fail, as we have seen, which simply highlights, and that's the contra-argument, simply highlights the opinion of Dr. Reese. So I think 31 years does make a difference.
And what role does it play that the defendant waits 31 years to raise the issue?
I would suggest to you, if you go back in 2005, I believe it was, Mr. Murray raised that issue by contacting the clerk and asking for some documentation. And from out of that, and some of the comments that were made, and that was a preference to, or prerequisite to a 60-1507. I think you could make a reasonable case that Mr. Murray didn't know the result of that competency hearing, didn't know what was going on, and then he tried to raise it in the ineffective assistance of counsel claim that he made, and that didn't go anywhere. Finally, he files the motion to correct an illegal sentence where it clearly was raised. Mr. Barty raised that issue, and it ended up here.
But counsel was aware of what was going on, and it would have been counsel probably that would have been the one that would have brought an expert into the picture for the defense.
Nobody remembers what happened. That's part of the problem.
But
It would seem, I'm sorry.
But doesn't, I mean, again, back to that question, does some of that responsibility fall, perhaps not individually on the defense, but the defendant, but the defense team, to have come forward with something to indicate we would have had an expert?
Well, I think what happened here, as is clear from the testimony, things were a little loose back in that day, and no one has a clear mind as to what happened. Certainly Mr. Cornwell didn't when he testified, but certain things jumped out, which I think makes more of the case, and that is he remembers that Mr. Murray was not operating on all cylinders. He remembers he was afraid that Mr. Murray was going to jump out the window. There was an additional witness who thought Mr. Murray was crazy. There was Mr. Murray's testimony that he had suffered head trauma and couldn't remember very well, et cetera, et cetera. So at that point in time, we would like to say that Mr. Cornwell, had it gone to hearing, which it didn't, had it gone to hearing, it's reasonable because Mr. Cornwell is an experienced attorney, he could have brought in some expertise to contradict Dr. Reese's.
Wasn't there either a parallel, I'm not sure how to characterize it, a parallel or a companion case during this period of time in which Mr. Cornwell represented your client and actually entered a plea in a case?
Yes,
At
there
that
was
same time, and he testified at this hearing that had there been a concern about his competency, he couldn't imagine going forward with that plea. Doesn't that contradict your concerns or the lack of a record here about what was going on? I mean, that seems pretty clear to me that Mr. Cornwell was satisfied of his competency, and this was after the doctor's report came back to the court.
That was on the escape charge, as I recall it, and I think you're accurate on that. And I'm not certain that Mr. Cornwell was as forceful as that in the testimony, but I can stand to be corrected.
I need to know, make sure I know what we're talking about. When you say 31 years is the last, are you saying that makes it really, really hard to do a reconstruction kind of hearing, or are you saying that per se you cannot do it? And so the rule ought to be per se.
I think that's what I would like the court to hold. I mean,
So if that's what you want us to hold, and you said 2 or 3 years might be okay, but 31's too much, what's the test in order to invoke the per se rule?
that's exactly my point. We don't know. What I'm urging you to find that there is at some point, and 31 years seems to be one of those points, but it's unclear in the case law, it's unclear in Davis, which everybody used here, that memories had failed, all of the argument that I made before. So,
But, I mean, why isn't the length of time simply one of the ingredients in the analysis? For example, if it was 31 years, and you didn't, and the file didn't have the contemporaneous letter from Dr. Reese. So if you don't have that, and then all you've got Carl Cornwell showing up saying, I don't remember, but I took this plea, and the district attorney at the time saying, well, I don't really remember, but this is how we did it, then that could lead to a reasonable determination that could be reviewed on appeal, that in this instance, 31 years was too much. But if you have other things to play with in the analysis, why can't you play with it? Why can't you factor those in? Like having a contemporaneous letter in the file that shows you what the doctor would have said at the time. That's the
Were a
part I
couple
don't.
questions
That's the
that-
part I don't get out of trying to come up with a per se rule.
It's difficult to do that. What we do know is that in Davis, this court quoted McGregor, and it said that the lack of contemporaneous medical evidence are amplified by further difficulties that necessarily arise from significant passage of time. I guess what I'm saying that due process assumes a meaningful hearing at a meaningful time and the opportunity to have your say and opportunity to speak and the opportunity to deflect all of this evidence. So I guess what I'm saying, and probably not very well, is that there has to be a time in which there must be an assumption that memories have failed so much that you can't reconstruct it. But I agree with your point. Here we have this letter that says, I find the defendant to be competent. But I'll go back to my original point, and that is that how in the world do you put on evidence to mitigate that?
Counsel,
Yes.
I have a follow-up question that might help clarify. It might help me clarify in my mind, at least. It seems like you're advocating a per se rule, and you've got two rationales for it that you've articulated. One, the passage of time and fading memories, that sort of category of reasons. But you've advocated a second reason, which is that the defendant does not have the ability, because of the passage of time, to bring opposing evidence, to essentially hire his own expert to prepare a contemporaneous evaluation, which might contradict the state's expert. Is that, I mean, that's a fair characterization.
That's what I've said.
So I get back to my original question. It seems to me that on that second rationale that I described, the passage of time is much less relevant. In other words, I guess what I'm asking you is, it strikes me that you're arguing that Davis was wrongly decided, and that once the defendant has lost the ability to bring evidence based on a contemporaneous evaluation, that's just it. You just can't go back and redo it.
Well, what I'm really saying is that I'm not saying Davis is wrong, but Davis didn't go into the exaggerated time elapse that we have in this case. And perhaps if this court would clarify that, it might be helpful. But here in Davis, there was 3 years elapsed time. And in this case, 31 years, obviously. So this court in Davis never elaborated on what is the ultimate passage of time, what is the effect on due process. Is there a point in which it is just per se a violation of due process?
Counsel, that gets back, I think, to Justice Breyer's question, whether this is a due process violation or a jurisdictional problem, because the passage of 31 years could mean that, or could be a basis to find that the defendant waived any due process irregularity, because that's waivable. Due process is waivable. And having gone to trial, now the statute says you stay the proceeding until you have a competency hearing. But if the defendant went to trial without insisting on having that hearing, one could find that that was a waiver of any due process violation, but you couldn't say that's a waiver of jurisdiction. So that's why that is critical as to whether the stay until you have suspends jurisdiction or is simply a due process. Because, I mean, you're talking about whether waiver can apply.
Let me put it this way. It's our position that if there wasn't a hearing, there was a motion on file. There was never a hearing. At the point that that motion is on file, the law is very clear that the court at that point lacked jurisdiction. So it is our position, but the due process argument is separate yet part of that argument, I think.
It's not just that a motion was on file. You can file a motion to suppress,
But there's
never
an
bring
order.
it, never bring it to a hearing, proceed with trial, and you don't have, it's not ultra vires, it's not without jurisdiction. The only place that you're hanging your hat is where we have said that the statute says the court shall stay the proceedings until you have a hearing.
What I didn't say was there was an order on file to stay proceedings. So it just wasn't the motion, there was an order. I know this is my argument is somewhat convoluted, but I just keep going back to the fact that so much time has gone by, and you can see by the testimony of Mr. Cornwell, you can see by the testimony of Dr. Reese, how do you cross-examine Dr. Reese when he says, I don't remember anything else? I mean, that's a difficulty. And how do you cross-examine him? Well, how did you come to that conclusion? Well, I don't remember. It says right here he's competent. So time wears on the ability to make your case in contradiction of Dr. Reese.
Are there other questions? Thank you, Counsel.
Thank you.
May it please the court. My name is Jerome Gorman, District Attorney in Wyandotte County. I don't want to give up on the idea that there was no hearing. I realize that there is no docket entry that proves that there was no hearing. But I think that if you take a common sense approach of the docket entries that we have and the documents that we have and the actions of the parties, that I think it leads to that common sense conclusion that there was a hearing.
The
And here's
district court didn't make that finding, as I recall.
it's not recorded.
No, I'm talking about the district court that looked at this motion for a legal sentence. So whether there was or wasn't a hearing, we're sort of stuck with whatever is in the district court's order. How do we bring common sense to that factual determination at the appellate level if it wasn't first made by the district court?
Well, those facts, the things that I'm talking about, are all in the record. And I realize that's not what Judge Lampson hung his hat on when he filed his order. But all of those facts that I'm referring to and circumstances I'm referring to were part of the record of that hearing in January of 2013, is all I'm saying. And I think the big thing that I would point to is, obviously the court and the parties recognized that the proceedings were stayed once that order for competency was made, because the preliminary hearing was scheduled for March 15th. On March 1st, it was scheduled for March 15th. The motion and order for competency comes along on March 10th. The parties reassemble on March 15th and set a new preliminary hearing date. I think it becomes obvious that the reason they did that is because of the March 10th hearing date. And they reissue subpoenas a second time. I think that's evidence that they recognized that they were stayed. And then there is, and there is the issue of that there is a competency examination actually done in this case. And there's evidence of it. It's not a reconstructed competency hearing. There's a letter of competency, and that's typically how they were always done then and still are, is that the examiner submits a letter. That letter is dated March 28th, and it has the notice to the parties on it and to the court, and then they proceed on March 29th.
What about Mr. Wells's point that as time has elapsed, Justice Stiegel's point, really any time that elapsed, negates the opportunity to rebut the report?
Well, I understand that as time elapses, memories elapse. I think that was obvious in this case.
I'm talking about the opportunity then. You have a report that's 30 years old. You do have the opportunity to present evidence at a competency evaluation. And how is it that you present evidence that's contrary to the report? How is it that you reconstruct what Mr. Murray's state of mind would have been at the time in 1983?
Well, I'll answer it in these two ways. Number one, as you noted a little earlier, there was a parallel case. When Mr. Murray was being brought into the Wyandotte County Jail on this case on warrant, he escaped from deputies for several blocks and that. That case, in June of 1983, which is about the time the jury trial took place, he actually entered into a plea of guilty in that case.
Right.
And there was a petition for a plea of guilty in that case, and we brought that up in the hearing. In that petition for plea of guilty, he states in point number 2 that I've never been confined in any institution for the treatment of mental illness, nor been adjudicated mentally incompetent.
But counsel, that's evidence in favor of the state's position that he was competent, right?
Yes, absolutely.
But the question is, and I realize this may be uncomfortable for me to ask you this question, but wearing a defense attorney's hat, the question is how, from the defendant's perspective, is he supposed to marshal evidence that he was competent in 1983?
Well, I guess what I'm saying is by showing that the defendant didn't have any evidence to marshal in 1983, because he already said, I'm competent.
Well, had a hearing been conducted, at least conceptually, theoretically, a defendant has an opportunity, and this oftentimes doesn't happen, but sometimes it does, for the defendant to obtain an independent evaluation, which might be used to rebut the state's evidence. And that happens at hearings when they occur during the normal course of these proceedings.
I agree. I guess what I'm saying is, had there been any question in either the defendant's mind or defense counsel's mind, where they would have had that evidence to rebut with, that it would have somehow come out either in the jury trial or in the plea hearing. Because not only did the defendant say he'd not been found mentally incompetent, but in the certificate of counsel on there, Mr. Cornwell said, and am satisfied that the defendant is physically and mentally competent to understand these charges.
It sounds like you're arguing that and I don't want to put words in your mouth, but correct me if I'm wrong. It sounds like you're arguing that essentially, even if there had been some evidence of incompetency and there was an error because it wasn't allowed to be presented, that error is harmless because we have plenty of evidence that he was competent.
Well, exactly. I am saying that there was plenty of evidence to show that. And there's plenty of evidence that nobody else believed that he was incompetent at that time, too. If we go back to the original motion that Mr. Cornwell filed, I can't remember the exact language of it, but it was pretty generic language where he said, I met with him in the jail and he just didn't seem right. He doesn't point to anything specific. Today, I probably, if I was presented that motion to determine competency, would have challenged the motion to determine competency, saying that it wasn't sufficient. I can't remember the exact language in there, but it says something to the effect that the court has to find a basis to believe. And under the original allegation that Mr. Cornwell even presented, didn't even present any factual matter.
But But that isn't the case. There was a evaluation order, okay, and statutorily, there should have been a hearing, based on the motion, okay? That hearing wasn't held, as far as we know. Is that hearing waivable? Can a defendant waive the hearing, or can a defendant's attorney waive the hearing?
I'm afraid by answering this, I hate to give up the aspect that I think that a hearing was held, and I think the facts show that a hearing was held. It wasn't recorded. But to try to answer directly your question is I guess, yeah, I have to believe that it's waivable, or we've lost a 31-year-old murder conviction.
But is it waivable by defense counsel? You indicate that, I don't find it compelling that a defendant who is questionably competent signs off and says, I'm competent. But it is more compelling that the defense attorney signs off and says my client is in a state of mind to enter this plea. But I'm asking if that defense attorney could have also waived the competency hearing on behalf of his client without getting a personal, voluntary, freely, knowingly made waiver in open court.
I'm trying to, I suppose that analysis would require that it be a constitutional right to the competency.
To the hearing as opposed to jurisdictional bar. That's what you're getting at, right?
Okay.
Obviously, you have a due process right to notice an opportunity to be heard. And if that's our only problem here, I think we found that's waivable. But I think you'd have to show that it was waived by the defendant, not the defendant's counsel.
Okay. I guess, Justice Johnson, going back to the Davis case, this court didn't find that they found it was a due process hearing, a due process problem there. And I don't believe that in that hearing there was any issue, or in that case there was any issue with jurisdiction, or that was even argued.
Then if it's not a jurisdiction problem, then the motion to correct the illegal sentence doesn't really apply, does it? I mean, the only way we get to that motion is, we've said it's an illegal sentence if it was imposed without jurisdiction. And just the fact there were some due process violations in the trial doesn't make the sentence illegal.
Well, I suppose under the case law that we've developed under motion to correct an illegal sentence should correct, it wouldn't apply, but the case law that we've developed that said that if it's something else but we've called it the wrong thing, then we'll look at it as a 1507 would apply, and the same argument, I guess, is made then that it's not jurisdictional, but it's a due process, and that what we've shown through the reconstructed hearing, the retrospective competency hearing, is, I believe, we've overcome that due process hurdle.
Counsel, I kind of have to apologize for asking this question because I didn't think about it until I was just up here. I posed the question to both counsels. Did you guys check to see whether the 1983 version of 223302 was the same as what you were quoting in the briefs? Because neither one of your briefs say that it's the version that was in effect back when Ike and Tina were singing and Ronald Reagan was president. And I am trying to dig around here on the computer, but it's distracting me from listening to it. So
I can't say for sure, but I believe that when we went into the hearing in 2013 that I checked, the statute was substantially the same. I believe it was.
Okay. But you can't tell me what you quoted in the brief is which version.
I cannot.
That's fine. That's fine.
Okay.
I'll pull up the session.
Okay. I don't have any further argument with the court. The court has no further questions.
I think that the earlier opinion in this case said that the statute. Both times.
I have no further argument.
Or any further questions? Thank you, Counsel.
If I did not make this point strongly enough in earlier questioning from the court, let me make it clear now. If there is no hearing, there is a motion and an order filed for competency hearing, and there's no hearing, and I think the evidence is pretty clear here, particularly, again, from Judge Grosco, that there was no hearing, despite my friend Mr. Gorman's contrary position. There's no jurisdiction, period. No hearing, no jurisdiction.
And you base that entirely on Davis or on something else?
Well, Davis quotes some federal law, et cetera, but yes, Davis, I think that's Davis's point, that you can resurrect that by going back and conducting, or at least looking for and conducting a hearing.
What's your answer to Justice Johnson's questions regarding whether the hearing is waivable? In other words, counsel sees the report from the doctor, reads it, and said,
I don't think you can waive it, because if the court doesn't have jurisdiction, how can you receive a waiver? I mean, how can you waive something when a court, at the point that there's no hearing or the order is signed and there's no jurisdiction, how is it possible to make a ruling or a finding that there was a waiver?
So you have to dismiss the case at that point? I mean, obviously, the court has jurisdiction to rule on the competency, so there is
Yes,
jurisdiction.
but they didn't.
The only question is there jurisdiction to proceed with trial? Not that there is a lack of any jurisdiction over anything. Because the issue before the court at that time is competency.
Right.
The court retains jurisdiction over the issue of competency. And if it has jurisdiction to rule on the competency, why doesn't it have jurisdiction to rule on a waiver of further hearing and submit it based on the report?
How can you waive, if you are incompetent, or there's a question of incompetency, how can you then enter into a waiver as a defendant?
Any further questions? Court will take this matter under advisement. We're in recess until tomorrow.